Hello everyone, this is the video of Legal Studies, Class 12, Unit 2nd, that is Topics of Law, and the topic that we have been discussing from last a few classes, that is tort law, and the subtopic that I will discuss in this video, that is negligence. So let's begin with the meaning and concept of negligence. However, before discussing the meaning and concept of negligence, let's first discuss what are the key terms that I will be discussing in this video. The first key term that I will discuss in this video, that is what is the meaning of negligence. The second one that I am going to discuss, that is what are the essential elements of negligence. And the third one, that is what are the defenses of negligence. And the last one that I will discuss in this video, that is what are the remedies of negligence. Likewise, in this video, I will discuss about the 4 elements of negligence. Okay, so let's begin with the meaning of negligence. Okay, so what comes in mind when you discuss about the negligence? What comes in mind? It is something like that you didn't pay attention, whether that act was intentional or negligent. In such a condition, both type of negligence is possible. Say, you know that driving car at high speed is risky, and secondly, the caution is given at roadside that your speed limit should be 60, but you didn't pay attention, you neglect that fact, and you met with an accident, and because of your negligence someone else suffered. So it was deliberate negligence because you ignored the fact. Sometimes the negligence possible that you didn't pay attention simply because you should have taken the reasonable diligence, care, but you forgot to do that, and it happened unintentionally. You can say like that, unintentionally. So that is negligence but not intentional. So in both the cases, if you damaged someone's property, body, or anything of such type, you will be held responsible for that. Okay, so this is the concept that we will discuss under the heading of negligence. Okay, so now let's check out what are the legal terms, legal definitions, and legal explanations of negligence. So let's begin with the first one, that is negligence is derived from Latin term negligentia, which means to neglect or not to pick up something, as we have seen in the example of that exceeding the speed limit, crossing the given caution. Okay, so in a common language, negligence means the failure to exercise the care that a reasonable, prudent person would have been exercised in the given circumstance. So, see, there are certain terms that you need to understand in order to understand the term negligence. What it is said here, in a common language, negligence means the failure, means if something you can do but you didn't do or you couldn't do, so that is your failure. If something that is beyond your control, we are not discussing something about that. But something that is in your control, but because of your carelessness, you couldn't do that. So that is your failure to exercise the care. that a reasonable prudent person, so any reasonable prudent person can have taken that sort of precautions in that given circumstance, and you didn't take. So in that condition, whatever the mistake and whatever the accident you caused, you will be held responsible. So that is the meaning of negligence in this context. So in case of negligence or tort, the harm is caused because of carelessness, we can say like that, and not by the intentional act, as we have seen in case of intentional tort, because we have discussed number of intentional tort. If you remember, in all the intentional tort, whether it is battery, assault, wrongful confinement, okay, trespass to chattel, etc., in every act we have seen that all those acts were intentional, but here it is negligent act, okay, but still the defendant and the wrongdoer is responsible. Pay attention. Likewise, in the case of negligence, the injured person, plaintiff, you can say that, has the legal right to demand and get compensation for the harm to his or her body, property, mental well-being, financial status, or intimate relationship. So whatever the damage the wrongdoer caused to the plaintiff or the claimant, whether it is financial or bodily injury or some property damage or relationship damage, so whatever it is, the defendant will be responsible for that. Okay, so that is the concept of negligence. Our next question that we have seen, that is, what are the essential elements of negligence? Following are some of the essential elements of negligence, that is, duty of care to the victim. Okay, the next one is breach of duty of care on part of the defendant, and the last one is the breach of the duty to care resulted in the harm suffered by the claimant. Okay, so now let's understand all these three essential elements, though we will discuss in detail on subsequent slides, but now you first understand it in brief. As you can see the given image, what it is shown that a person who is driving, so what are the other things he is doing? He is eating, you can see that. He is also texting someone on his cell phone and also driving. See, while doing all these things, along with the driving, accident is bound to happen. You don't think so? And see, in front of him there is a child, he is driving. And see, in front of him there is a child on his cycle. So if he won't pay attention on the road, what will happen? You know that. So now let's check out all these three essential elements through this image. The first thing, when this person is driving on the road, it is his duty to take care of the things and what is coming on his way on the road. But since he is doing something else along with the driving, so the second element, that is breach of duty. So it is breach of duty. And the first one, that we have seen that since he is driving, so it is his duty to take care what are the things coming on his way. And since he is not paying attention on that, so it is breach of duty. Okay. And definitely he is going to hit the boy. So the moment he hits the boy, that is become the harmful act or negligent act that caused injury to that boy. So the first element, duty of care, of course he had here. Second one, breach of duty, he did it because of his attention was somewhere else. And thirdly, the breach of the duty to take care resulted in the harm. That boy got injury. Okay, so all three essential elements are proved in this image. Okay, so this is the clear-cut example of negligence. Okay, now let's discuss duty of care. What exactly duty of care? The principle of duty to take care is the first step to prove the tortious liability for the negligence, as the tort of negligence includes injury or damage due to negligence. Therefore, in order to prove it, the plaintiff has to prove first that the defendant is under a duty of care that he missed and the result of which plaintiff suffered the injury or damage. However, the burden of proof that the defendant has been breached the duty lies upon the plaintiff. So what does it mean? That it is simply saying that once you are claiming, the plaintiff claiming that he received some injury because of the wrongful act of B or defendant, then A, who is plaintiff, needs to prove it that B did it, and A also needs to prove that there B had duty to take care, but he ignored that, he didn't pay attention of that duty, and negligently he caused injury to plaintiff. So it is plaintiff's duty to prove it first. Only then court can go with plaintiff and make available the damages, isn't it? Without proving, it is very difficult. So the principle of duty to take care evolved in the case of Donggu versus Stevenson in 1932. This case explained the law of negligence. It's a very interesting case. What happened? An English lady who was invited by her friend, and she went in a restaurant to meet with her. After going in the restaurant, she offered some snacks and some soft drink and all. So in ginger beer, that is one of the drinks that she had been offered, she found a decomposed snail. Later, because of which she fallen ill. And this beer was supplied by a manufacturer, namely Stevenson, in Scotland. So Donggu sued Stevenson. However, the fact was there was no contractual relationship with Stevenson, and secondly, on her behalf, her friend paid the money. So there was no contract and no doctrine of privity as well. So in this case, Donggu had no right to claim, as argued by Stevenson. But the court held that the manufacturer owed duty of care to those who are reasonably foreseeable to be affected by the product. So the duty of care is owed to those whom one can reasonably foresee as being potentially harmed. Though the fact is she didn't pay, but the fact is she consumed that and she fallen ill because of that decomposed snail that found in her drink. So it is Stevenson's negligence that he didn't pay attention while manufacturing that beer. So Stevenson's found guilty and he paid the compensation. Okay. Further, in the case of Capro versus Dickman, that is 1990 case, the court introduced the threefold test to prove duty of care. The first one is reasonably foreseeable. What does it mean? That the kind of thing, the kind of act that can we reasonably can assume. Any prudent person can assume that in certain circumstance, in given circumstance, this is possible to happen. So that is reasonably foreseeable. Okay. So you are required to take precaution in advance if condition is something like that. For example, if you are taking back your car in order to take turn, so it is your duty to take proper care while taking your car back. Is there someone who can become victim of your car as you are taking back? So it is your duty to see first your back and then take back. Okay, so if you didn't do that, you cannot say that you didn't pay attention your back. Okay, because it is reasonably foreseeable. Okay, the next one is there must be a relationship of proximity between the plaintiff and defendant. Okay, so what does it mean that there must be relationship of proximity between the plaintiff and defendant? So this is talking about a sort of relationship. I give you another example in order to understand this. See, in a parking, a few boys playing ball. A person went in order to take out his car and he didn't pay attention while taking back, and all these acts had been observed by a lady who was standing in her gallery. And what happened while taking back his car, she had seen that her son being hit by that car and she fainted. But actually she didn't see that what happened there. But whatever she had seen, she thought that her son was hit by that car and she fainted and all. So in that condition, if anything happened to that boy who was playing in that parking lot, for that this gentleman who was taking back his car is responsible. As you can see there must be a relationship of proximity between the plaintiff and defendant. Okay, so there is relationship of proximity here between that boy and that driver. Okay, but whatever the wrong happened with that lady, the mother of that boy, he is not responsible because that doesn't come under the relationship of proximity, because that is reasonably not foreseeable. Just check out the first one, that is reasonably foreseeable. That is not reasonably foreseeable by that gentleman. Okay, so for that injury, for that damage, this gentleman won't be liable. But of course, if anything wrong happened to that boy, this gentleman definitely will be liable because there was duty to care and he didn't do that. The last one is it must be fair, just or reasonable to impose liability. So whatever the liability and all the things which supposed to be imposing upon the defendant, that has to be fair, just and reasonable. It's not like that if this is something like unliquidated damages, as we have studied that unliquidated damages in our previous classes. So it's not like that you can demand any amount. Whatever the damages, the compensation, you will be demanding, that has to be fair, just and reasonable. So these three principles are there to decide. Okay. Now the second concept that we have discussed, that is breach of duty. So what does it mean? So breach of duty means not only the breach of obligation or duty arose through the contractual agreement, but it has also general meaning, where in a society every member has a duty to exercise reasonable care toward others and their property. So, if you are living in a society, then it is our duty to take care of others' right as well as property. Therefore, in such a case, if any person fails to exercise his duty of care reasonably, I am repeatedly using the word reasonably, so please pay attention on this word reasonably, and it causes injury or damage to other person, then he will be liable for such damage. However, it must be reasonable and foreseeable. Okay, so in the image that you can see that two gentlemen, they are just looking after the things. They hit the vehicles of each other, isn't it? Now, the third and the last concept is that is harm to the claimant. However, in order to prove guilty to a person or defendant, it must be proved that because of his commission or omission of an act which he reasonably owed, the plaintiff suffered the injury or damage. So, it is duty of claimant to prove that because of defendant's some act that he should have done or he should haven't done, both the condition, commission or omission. In both the condition, if plaintiff suffered the injury or damage, then defendant will be liable. Okay. Now, our next point is, what are the defenses of negligence? So, say you committed some mistake or negligently caused injury to someone else. So, what are the conditions in which you will be escaped or you won't be held liable to pay the compensation? So, there are certain conditions in which you can escape from the situation. So, let's check out what are those conditions. The first one is the defendant has taken all the due care, but it was beyond the control of any common person. So, if something happened, you have taken all the due care, but the situation was beyond your control, or any person cannot control that situation in normal circumstance, then you won't be liable. The next one is the incident was so accidental that cannot be speculated in a reasonable circumstance. That is not foreseeable. You can say that. So you can think something in advance, fine, but there are certain things that cannot be speculated in advance and that happened. For that you won't be liable. The third one is plaintiff couldn't prove any injury or damage. Though plaintiff claiming that because of B I have suffered such injury or damage, but he couldn't prove that actually he suffered some injury. In that condition, again, the defendant won't be held liable. Next one is the defendant warned the plaintiff about the possible danger. However, plaintiff gave his consent at his own risk. Okay, so if something happened like that, you can take the example of the things that say you're walking on the floor of a hotel, though some cleaning work is going on and caution has been put there that floor is wet, so take precaution, but you didn't pay attention on that caution and you made an accident, you will be responsible. If someone driving fast, he said that I drive fast, so don't sit with me or in my car. Even then, plaintiff said that no, I am ready to take risk. Even in that condition, plaintiff has given his consent So defendant won't be liable. And the last one is act of God. So if something happened that is again beyond your control, so how you will be responsible for that? There are certain acts that you know, like earthquake, है ना? Landslide, flood. All these things are something like that that you cannot control. So of course you won't be responsible. And the last point of our topic is, what are the remedies of negligence? In case the injury or damage is proved because of the negligence of defendant, then defendant will be liable to pay the compensation or damages to the plaintiff. You know that in tort law, compensation or damages prima facie is the most prominent remedy. Okay, so this is all about the negligence that we have discussed, about the meaning and concept of negligence, the essential elements of negligence, the defenses against the negligence, and lastly, of course, remedies of negligence. Hope you understood this concept. See you in next video.